I'm here at the office of Walt Adams, who is the Illinois State Counsel for the Fidelity National Title Group, which encompasses Chicago Title Insurance Company, Commonwealth Land Title Insurance Company, and Fidelity National Title Insurance Company. Today's topic will be about how bankruptcies affect liens on real estate.
Thank you. This is a general discussion of bankruptcies and their effect upon liens upon real estate in the state of Illinois. Like much bankruptcy law and federal law, it is highly dependent upon state law and what the states will deem to be a lien in the first place, and what methods may be used to defeat a lien underneath state law. So this is very Illinois specific. This issue comes up quite a bit. We're running title on a piece of property. We find a judgment. We'll start out saying it's a judgment against our seller. We raise the judgment. And the seller comes in and says, my bankruptcy attorney gave me these papers. He says that you shouldn't be raising that. You don't know what you're doing. And they hand you a petition in bankruptcy or a discharge paper saying they were discharged in bankruptcy. Can you waive the lien on that basis? And the general answer is no, we cannot. Let's just say it's Walt Adams. Walt Adams owns a piece of real estate, and there's a judgment against him in favor of Acme Petroleum. I filed my bankruptcy papers. I list Acme Petroleum as a creditor in my bankruptcy, and I get my discharge. That lien is not affected as it's secured by the real estate. So once you have that lien that's already attached to the real estate that you own, your bankruptcy discharge does not wipe that lien out. What that bankruptcy discharge means is they can't garnish Walter Adams' wages anymore. And it does have another effect if I was purchasing property that we'll talk about in a little bit. But it does not eliminate the secured claim on my real estate. There's only two ways that a secured lien on real estate is wiped out by a bankruptcy. One of those is my bankruptcy trustee sells that property free and clear of liens, which is a topic for another discussion. The other way is if that bankruptcy court enters a specific court order removing that lien from my real estate. And believe me, it doesn't happen very often because bankruptcy attorneys don't usually run title reports on all the real estate owned by their clients. So they simply don't know about the lien that's on the real estate. Often we wind up seeing bankruptcies reopened in order to get that order after the title company has brought it to their attention that that lien has not been eliminated. And the bankruptcy court can eliminate that lien if it's the homestead of the individual and it infringes upon their homestead exemption, or if it's a preference. And there may be another reason, but there has to be only a few very good reasons that the bankruptcy court will remove that as a lien upon the real estate. Once you have that bankruptcy court order removing the lien on the real estate, you can rely upon it and waive the judgment after 14 days elapse of the appeal period in bankruptcy court. And then you can close on your transaction without paying that lien off if you have the court order. But generally, the discharge means nothing. You have to have a specific court order or a bankruptcy sale free and clear for a bankruptcy to affect an existing lien on your seller's real estate. How else does this come into play? Sometimes we have buyers, and many title companies still run the buyers' names for judgments. Not all, but most of us, I think, still do. When we have the buyer's judgment, then perhaps the bankruptcy will have an effect because that lien is not attached yet. That buyer is not entitled to the property. And there is what they call the fresh start theory of bankruptcy, which means once you're discharged, you're now given a fresh start. So if that lien is dischargeable, and some liens are not dischargeable, for example, child support liens, student loan liens are not dischargeable in bankruptcy. If it is dischargeable and it has been discharged and they did receive their discharge, then that lien would not attach to property they buy after their discharge in bankruptcy because they have a fresh start. But that means we have to go back into the bankruptcy court file, and we use a PACER online services, which is a government website, very easy to use, very inexpensive. And we make sure that creditor was listed. We make sure that there's a dischargeable debt. We make sure that they did receive a discharge. And if those three things are met, we can waive that lien and not have to worry about it as a lien that will attach once that purchaser comes into title. So just remember the basics. Liens do not affect, bankruptcies do not affect existing liens against your seller unless the property is sold free and clear, or if there is a bankruptcy court order removing them. Bankruptcies can affect a lien against a buyer of real estate if that lien has been discharged prior to their coming into title to the real estate. Again, if you have any of these issues, if you're a consumer, please consult with the attorney of your choice. If you're in the industry, please consult the Fidelity National Title Group underwriter of your choice. And the opinions expressed herein are my own and not those of the company. Thank you.